My name is Richard Moon, and I'm a member of the law faculty at the University of Windsor. Yeah, there's a couple of general things that it's important to know about the Charter to begin with. The first, of course, well, you know, it includes a number of different rights, some of which are described as fundamental freedoms, like freedom of expression, religious freedom, freedom of association, and so forth. Equality rights, a number of more particular rights, mobility rights, language rights, and so forth. So, and of course a lot of rights related to the criminal process, the trial process, and so forth. So that's the first thing, its general scope. But it's important to know that the rights in the Charter are understood to be rights against the government. And by that I mean that, that the only claim an individual has, the rights are held by individuals, but the only claim an individual has is in relation to government action. So if somebody, prevents me from speaking, or somebody discriminates against me in the private sector, so an employer or a landlord renting an apartment to me, I don't actually have a charter claim against them. I may have a claim under human rights legislation within the province or federal human rights legislation and so forth, but I don't have a claim against the Charter. So an important dimension of the Charter then is it has to be established that a government actor of some kind, could be the legislature enacting a particular law, or a police officer, somebody who is carrying out the law and has particular public responsibilities, that I have to show that it was a government actor, a government action that has interfered with my rights or freedoms. So that's something that's important to know. The other thing is, all these rights in the Charter are set out in fairly broad terms. Freedom of expression, freedom of conscience and religion, very wide open, abstract in character. But the Charter is structured in such a way that these rights are protected, but according to Section 1 of the Charter, they are subject to limits that are prescribed by law, reasonable, and demonstrably justified in a free and democratic society. So in most Charter litigation, in most cases that come before the courts where somebody argues that their Charter rights have been breached, there are really two stages to the case. The first is the individual who is arguing that his or her Charter right has been breached has to make that case. They have to establish, what I was doing was expression, and this law has restricted my expression in a particular way. And once it's decided that a particular right has been breached, for example, my freedom of expression rights have been breached by government action of some kind, then the case shifts to a second stage. And then the onus shifts to the government to make the case that this restriction on my expression, or whatever right or freedom we're speaking of, that this restriction is justified in the terms of Section 1. So it's prescribed by law, in other words, it has legal form of some kind, and that it's demonstrably justified in a free and democratic society. Well, that's a pretty open-ended idea. The courts, in an early decision known as Regina and Oakes, sought to develop a multi-part test for determining what counts as a reasonable restriction on a right or freedom. Now I can describe that test if you want. All right, that test has several parts to it. The first question that gets asked is, behind the government action, behind the legislation, if that's what we're speaking of, is there a pressing and substantial purpose? So is the restriction the right or freedom? Is it pursuing a substantial and pressing purpose? The next questions are, is the government's restriction, is the restriction on the right or freedom, is it rationally connected to that pressing and substantial purpose? So is there kind of a reasonable, rational link between the restriction and what the government is claiming to do that is important? The next question, after the rational connections issue, as it's called, is the minimal impairment stage. So that question, at that point, the court asks, does the right or freedom, does the restrictive measure, the law that is purported that restricts the right or freedom, does it restrict the right or freedom more than it needs to advance its pressing and substantial purpose? Or is it drawn in an overly broad fashion? Does it restrict the right or freedom more than is necessary to pursue the objective that is pressing and substantial? And then the final question is really, it's called the proportionality stage, which is really about a kind of balancing of the costs and benefit. So do the benefits of the restriction, do they outweigh the costs to the right or freedom? And those then are the different questions the court asks and when trying to determine whether a restriction on a right or freedom is justified. They go through these different steps, and if the measure passes each of these steps, then the conclusion will be it's a justified restriction on a right or freedom.